necessarily objecting to the contents, all of them, but it's essentially rooted in lack of legislative competence of government in terms of Article 191. And the argument, my lord, is that because the powers and because this honorable court in 1980 had made rules, therefore the field stands occupied and in any event would not legislate. My lord, firstly, insofar as public importance is concerned, my lord would have now gone through the law and my lord would see that this law in fact deals with the concentration of powers, barring one provision, but concentration of powers in one office. What this law endeavors to do is, it democratizes this institution, brings more transparency, and structures the discretion, which is something, this structuring of discretion is something which has found favor with this court. The 7 principles enunciated in Amanullah case, 19 PLD 1990 Supreme Court 1092.
PLD 1990
Supreme Court 1092. Open policies, open plans, transparency, and so on, which this court has held that it is required of every, and of course it was with regards to the powers that the executive exercises. Now these are all administrative powers we are talking about. This law deals with largely, barring, of course, Section 3 was a question that was raised. I'd address towards the end, and Section 5, which I will address separately. So insofar as public importance is concerned, this law, in fact, deals with the issues which are important for public, which is the litigants. Secondly, insofar as independence of judiciary is concerned, my lords, there is no external element, which is to say that no other institution which has given any role whatsoever under this act insofar as practice and procedure of this court is concerned. It is all confined within this court. And that alone suffices insofar as the lack of any basis to challenge this act on the basis of violation of any fundamental right, because Article 9, yes, Article 9 as expounded by this court, access to justice and of course independence of judiciary is something which is which every citizen of this country is entitled to. So my respectful submission insofar as maintainability is concerned, these petitions fail on both counts. In continuum, as far as independence of judiciary is concerned, and I take your lordships to page 6 of this paper book. Starting from Government of India Act 1935, which was the first constitutional order of this country under which federal court rules 1850 were made. Under Section 214, subsection 1 of Government of India Act, the federal court could make rules but with the prior approval of the Governor General at that time. And in 1950, the Governor General, of course, was neither part of Parliament, there was no constitution, but under the Government of India Act, Governor General wore several hats and the executive authority vested in him and of course part of some legislative authority as well. Under the 1996 Constitution, Article 177 read with 3rd Schedule, Part 1, Clause 3, the rules were made with the prior approval of the president. There was not even a mention of any law as far as the 1956 Constitution is concerned.
There was
62.
62.
62. Under 1962 Constitution, Section 60, Article 65 said, subject to this Constitution and the law and with the prior approval of the President.
In 56 Constitution, the rule-making power was contained in third schedule.
Yes.
Had to be read with article, I forget what.
177.
That said
Subject to law and then
No, that says subject to law. It says subject to Act of Parliament.
Act of Parliament. But I'll address that, which my Lord has just pointed out.
वो ऐसी तो नहीं
जी,
है बात है।
I will address, my Lord, that question.
ऐसी बात तो ना करें।
My Lord, as far as, just bear with me.
आपने लिखा भी हुआ है यहाँ पे
Sir,
आर्टिकल
sir, एक second. I'll just, Article 177, I'll read it out, just for clarity. Until other provisions are made by an Act of Parliament. Third schedule would apply. And as far as 1956 Constitution is concerned, nothing happened under that Constitution, but the Constitution provision was until an Act of Parliament is made with the prior approval of the President.
rules were made.
The 56 वाले
Rules were made under the 56 Constitution.
56 Constitution and Act of Parliament was not made. 56 rules came with the prior approval of the President.
Is there any
So as far as
is there any difference between Act of Parliament and law?
I'll address that question, my lord. This is a question that I've noted. I'll address it. Under the 1962 Constitution, Article 65, subject to the Constitution and the laws, Supreme Court could make with the prior approval of the President. And same position, it was same position under the interim Constitution of 1972, which is Article 193.
I'm sorry, my apologies to interrupt, but the question here is surely when Governor General is referred to and the President is referred to, that's the executive branch. The 73 Constitution had the models from going back to 1935 up to 1972. It eschewed the controlling power of the executive branch. So surely the argument there is that the framers of the Constitution expressly were trying to strengthen the independence of the judiciary and at least, if I may use the term, eliminating one particular branch from the equation. So the argument perhaps is worse of what you are saying.
No, I'm coming to that.
Keep
I'm
it-
coming
keep
to
it
that.
in mind.
No, I have it in mind. I have it in mind. And when I went through this, I noticed that the executive branch was removed, but not the legislative branch. So this is the effect of 1973. This is what has happened in Article 199. The executive action
It's
is.
a pointer in that of the direction in which constitutional law is traveling.
I'll address that. In my lords, under Article 145, Clause 1, it is subject to law and with the prior approval of the President, and so is the position in Bangladesh under Article 107, identical to what is in India and what we had.
With the Constitution, these references, when they say subject to approval of the President, is it unilateral discretion of the President, or it is President advised by the Chief Executive, albeit the Prime Minister, who that is?
My lord, so if we look at the jurisdictions where we have this position, of course, in India, he acts on the advice. And if, for example, under Article 191...
Government has the last say, not Parliament.
Yes. It was, no, my lord,
So
with
there's a
just prior
distinction.
approval.
The prior approval of the President means effectively prior approval of
The executive.
the Prime Minister, not the legislature.
Yes.
You said that in the Indian Constitution also it says subject to law, but that provision doesn't read like that. It's subject to the provisions of the law made by Parliament.
Yes.
So it's not subject to law.
I will come to that
Constitution and
when
law.
I take you to
There is a
Article
distinction.
191. I'll come to that. I'll come to that when I take you to
I'm
191.
just clarifying जो आपने argument किया.
My lord.
वहाँ ये नहीं लिखा.
जी, when I'll address subject to law, I'll be addressing.
Okay, you reproduce.
It's 6 and 7, yes, ma'am. Now, in other jurisdictions, in United States, for example, this is 28 U.S. Code, Chapter 131, Section 2071. The rules made by the Supreme Court have to be consistent with the acts of Congress. And the latest a development, a later development